Hello friends, today in this session we will be discussing an important topic of administrative law, which is classification of functions of administration. Dear students, the brief highlights of the present topic are to analyze the different functions of administration, to know the difficulties in categorization of functions, to study the need for the classification of administrative action, and to determine the difference between the functions of administration. The administrative law has classified actions of the administration into three types, namely administrative, legislative, judicial or quasi-judicial. Although attempts have been made to avoid such classification for reasons of practically vague distinctions amongst them. However, this labeling the functions cannot be avoided completely and requires a coordinated and consistent working of these three primary functions. Just like the three organs of the government, which essentially performs three classes of governmental functions: legislative, executive and judicial. The function of the legislature is to enact law, the executive is to administer the law, and the judiciary is to interpret the law and to declare what the law is. The administration performs variegated functions, ways to investigate, to prosecute, to prepare and to adopt schemes, to issue and cancel licenses, etc. To make rules, regulations and bylaws, to fix prices. Legislative, to adjudicate on disputes, to impose fines and penalties, etc. Dear students, let us ponder upon the difficulties in categorization of functions. The notion of administrative law revolves around the differentiation in classification of functions. When the legal validity of an order is challenged with reference to the principles of administrative law, the first thing that the courts may have to do is to identify the nature of the order impugned, because in many cases what norms are to be applied to assess its validity will depend on this identification. Difficulties in categorization emerge because of several reasons. 1. Authorities exercise not one but miscellany of functions. For example, the Election Commission exercises legislative, administrative as well as adjudicatory functions. Article 324 of Constitution of India establishes the Election Commission and lays its functions. 2. Many times a statute gives power to the administration to make orders for certain purposes. Such orders can be legislative or non-legislative in nature. Thus, under one statutory provision, all kinds of orders can be issued. For example, the Imports and Exports Control Act 1947 confers power on the central government to regulate import and export of commodities through an order published in the Gazette of India. Some of these orders may have been issued under one and the same statutory provision. Similarly, a statute may confer on the government the power to exempt any person from the operation of the statute. An exemption order may be characterized as legislative or administrative or quasi-judicial. Friends, let us study the need for classification. A question arises as to whether the functions performed by the executive authorities are purely administrative, quasi-judicial or quasi-legislative in character. The answer is very difficult, as there is no precise, scientific and perfect test to distinguish these functions from one another. A further difficulty arises in a case in which a single proceedings may at times combine various aspects of the three functions. The courts have not been able to formulate any definite test for the purpose of making such classification. The courts have not been able to formulate any definite test for the purpose of making such classification. Yet, such classification is essential and inevitable, as many consequences follow from it. For example, if the executive authority exercises a judicial or quasi-judicial function, it must follow the principles of natural justice and is amenable to the writ of certiorari or prohibition. But if it is an administrative, legislative or quasi-legislative function, this is not so. If the action of the executive authority is legislative in character, the requirement of publication, laying on the table, etc., should be complied with. But it is not necessary in the case of pure administrative action. Again, if the function is administrative, delegation is permissible. But if it is judicial, it cannot be delegated. An exercise of legislative power may not be held invalid on the ground of unreasonableness. But an administrative decision can be challenged as being unreasonable. It is therefore necessary to determine what type of function administrative authority performs. Legislative action. It may be noted that the legislative action of the administration is a rule-making function. When any administrative authority exercises law-making power delegated to it by the legislature, it is known as the rule-making action of the administration, or quasi-legislative action. Legislative action of the administration consists of making rules, regulations, bylaws, etc. Rule-making action of the administration partakes all the characteristic features which a normal legislative action possesses. Such characteristic features may be generality, prospectivity, and a behavior which bases action on policy, consideration, and creates rights or liabilities. However, these characteristic features are not without exception. In certain cases, administrative rule-making action may be particularized, retrospective, and based on evidence. In Union of India, Cenimite India Limited, according to Justice Chinnappa Reddy, a legislative action has 4 characteristics: generality, prospectivity, public interests, and rights and duties follow from it. Elaborating the characteristics of rule-making action of the administrative authority, the Supreme Court of India in State of Punjab versus Tehal Singh held that where the provisions of the statute provide for legislative activity, that is, making a legislative instrument or promulgation of general rule of conduct or a declaration by a notification, where the power exercised by the authority under statute does not concern the interest of an individual but relates to the public in general, or concerns a general direction of a general character and is not directed against an individual or to a particular situation, and lays down future course of action. Such action will generally held to be quasi-legislative action of the authority. It is on the basis of these characteristics that one can differentiate between quasi-legislative and quasi-judicial action. A quasi-judicial action is in contradiction to a quasi-legislative action is particularly based on facts of the case and declares a pre-existing right. In the same manner, the Committee on Ministers' Power, which was appointed in England in 1928, distinguished between administrative and quasi-legislative action on the ground that what the former is a process of performing particular acts or of making decisions involving the application of general rules to particular rules. The latter is the process of formulating a general rule of conduct without reference to particular cases and usually for future operation. A number of functions which have been held by the courts to be legislative are as under: fixation of price, declaration of a place to be a market yard, imposition of tax, extension of limits of a town area committee. Quasi-judicial action. According to Duhung-Moore Committee on Ministers' Power 1932, a pure judicial action presupposes a lease between 2 or more parties, and then it involves 4 requests. 1. Presentation of case. 2. If the dispute is a question of fact, the ascertainment of fact by means of evidence given by the parties. 3. If the dispute between them is a question of law, the submission of legal arguments by the parties. And number 4, a decision which disposes of the whole matter by applying the law to the facts. Thus, in pure judicial decision, the aforesaid said 4 requests must be present. If in a case these requests are present, it would be a judicial decision, even though it might have been given by any authority other than a court. For example, by a minister, board, executive authority, administrative officer, or administrative tribunal. However, the task of interpretation of laws is the exclusive domain of the courts. According to Committee on the Minister's Powers, the word causae, when prefixed to a legal term, generally means that the thing which is described by the word has some of the legal attributes denoted and connoted by the legal term, but that it has not all of them. The committee has expressed the view that a quasi-judicial decision equally presupposes an existing list between the two or more parties and involves the first one and second one, but does not necessarily involve the third one and never involves the fourth one. The place of fourth is in fact taken by the administrative action, the character of which is determined by the minister's choice. It means the minister is free to take administrative action on as he may think fit. The process of fourth is not necessary in disposing the matter. In Indian National Congress versus Institute of Social Welfare, the Apex Court defined the meaning and attributes of quasi-judicial function. Elaborating the law, the court identified three characteristics of quasi-judicial action. 1. It is in substance a determination, investigation of a question by the application of an objective standard to facts found in the light of pre-existing rules. 2. To declare rights and impose upon parties obligations affecting their civil rights. And number 3, that the investigation is subject to certain procedural attributes, contemplating an opportunity of presenting its case to the authority. Ascertainment of facts, and if the dispute be a question of law, on the presentation of legal arguments, and a decision resulting in the disposal of the matter on the findings on those questions of law and fact. The examples of quasi-judicial actions are disciplinary proceedings against students, dismissal of an employee on the ground of misconduct, cancellation, suspension, revocation or refusal to renew licenses or permit by licensing authority, confiscation of goods under the Sea Customs Act 1878, determination of citizenship. Administrative action. According to Chief Justice S.K. Mukherjee observed, I quote, "It may not be possible to frame an exhaustive definition of what executive function means and implies. Ordinarily, the executive connotes the residue of governmental functions that remains after legislative and judicial functions are taken away. Thus, administrative action is that action which is neither legislative nor judicial in character. And further, the executive function comprises both the determination of policy as well as carrying it into execution. This evidently includes the insertion of legislation, the maintenance of order, and the promotion of social and economic welfare. The direction of foreign policy, in fact, the carrying on or supervision of the general administration of the state. Though the distinction between quasi-judicial and administrative action has become blurred, yet it does not mean that there is no distinction between the two. If two persons are wearing similar coat, it does not mean that there is no difference between them. The difference between quasi-judicial and administrative action may not be of such practical consequence today, but it may still be relevant in determining the measure of natural justice applicable in a given situation. Dear friends, in A.K. Kripak versus Union of India, AIR 1970, Supreme Court 150, the court was of the view that in order to determine whether the action of the administrative authority is quasi-judicial or administrative one has to see the nature of power conferred and the consequences. In State of AP versus SMK Parsuram Gurukul, AIR 1973, Supreme Court 2237, replying to question whether the power of the government to appoint trustees under Section 15 of the AP Charitable and Hindu Religious Institutions and Endowments Act 1966 is quasi-judicial or administrative. The court held the function as administrative and laid down that if there is list between the parties and the opinion is to be formed on objective satisfaction, the action is quasi-judicial, otherwise administrative. Administrative action may be statutory, having the force of law, or non-statutory, devoid of such legal force. The bulk of the administrative action is statutory because a statute or the constitution gives it a legal force, but in some cases it may be non-statutory, such as issuing directions to subordinates not having the force of law, but its violation may be visited with disciplinary action. Though by and large, administrative action is discretionary and is based on subjective satisfaction. However, the administrative authority must act fairly, impartially, and reasonably. The examples of administrative actions are issuance of directions to subordinate officers not having the force of law, preventive detention, accusation or requisition of property, action setting up a commission of inquiry, assessment under Sales Tax Act, fact-finding action, and entering name in the register of police. Dear students, let us discuss the fourth function, that is ministerial action. A further distillate of administrative action is ministerial action. Ministerial action is that action of the administrative agency which is taken as a matter of duty imposed upon it by the law, devoid of any discretion or judgment. Therefore, a ministerial action involves the performance of a definite duty in respect of which there is no choice. Collection of revenue may be one of such ministerial action. Ministerial functions are exercised by taking active, often coercive measures, and administrative functions by mapping out policy and expediency with unfettered discretion. When an administrative agency is acting ministerially, it has no power to consult its own wishes, but when it is acting administratively, its standards are subjective and it follows its own wishes. Dear students, with this we conclude today's topic. Hope you would have understood the classification of functions very well. Goodbye and stay blessed.